So hello to everyone and welcome to the Law at the Library, a partnership between the Evanston Public Library, the Chicago Public Library, and the Chicago Bar Association. My name is Lorena Neal. My pronouns are she, her, and I'm the legal literacy librarian at the Evanston Public Library. We're delighted to have everyone here tonight to discuss renters and renting, landlord and tenant rights. Our presenter tonight is Connor Malloy from the Law Center for Better Housing, where he is a supervising attorney and the director of Rentervention. I'll tell you a little bit about the format for this evening, and then we'll get things started. I will introduce our speaker, who will then give the presentation, followed by a question and answer period. If you have any questions for our speaker, please type them into the Q&A window, which you will find near the bottom of your screen. You can also use the chat feature to ask your questions if you would prefer. I will collect your questions as they come up and give our presenter the opportunity to answer them at the end of the slideshow. So feel free to add your questions whenever you think of them. If you have any technical issues or questions, you can direct those to me in the chat as well. Our next Law at the Library topic will be changes in tax law, know before you file, on November 28th. And I will link the page with the schedule and registration links for that in the chat. You can also see videos of previous presentations in this series on the Evanston Public Library YouTube page. So I will post a link to our Law at the Library playlist in the chat as well, in case you're interested. We also have a list of general free and low-cost legal resources in the area on the Evanston Public Library website. So I'll add that link into the chat as well. Our speaker tonight is Connor Malloy. Connor is a Chicago-Kent College of Law graduate, currently serving as the project director for the Rentervention Initiative at the Law Center for Better Housing. Connor's work is committed to process automation, technology-driven legal practices, and improving access to justice through technology. Malloy is an accomplished legal professional who has significantly contributed to the field. He has served on the Tech Regulation Committee of the Chicago Bar Foundation and currently serves as the vice chair of the Illinois Supreme Court's Committee for Modernizing Service of Process. In 2018, the American Bar Association awarded him the Louis M. Brown Award for Legal Access. He also played a vital role in a chatbot project that won the same award in 2021. In 2023, Malloy received the Fast Case 50 Award, a recognition given to the most innovative and courageous individuals in law, and became a member of the inaugural Artificial Intelligence Innovation Lab at the 1871 Innovation Hub, continuing his mission to democratize the law through AI. Welcome, and over to you, Connor.
Thank you so much. All right, everybody, thank you for joining tonight. And I understand this will also be recorded. So for folks that are watching this later, thank you for tuning in. With that said, I'm just going to pull up a little bit of a slide deck. And as just mentioned, right, a lot of great programming for the Law at the Library program. Law at the Library program, that we see in the future here. With tonight being about renters' rights and renting. And it's just a little bit about my organization, the Law Center for Better Housing. Has a mission to where really just sees it where everybody has a right to safe, decent, and affordable housing at a baseline. What I want to talk about tonight are a few parts. First, I'm going to go into some basics about certain laws that govern areas such as Chicago, Evanston, Cook County, in some areas where they don't have a local law and otherwise. Once I go on from that, I'll talk a little bit about conditions issues that folks experience in their home and what to be able to do about that, especially when there might be an emergency. And next, I'll move into eviction-related matters. And then finally, I just want to do a brief tour of one of the things that I've developed called Rentervention, and explore that tool and what it can do for people. All right. So first things first, we have the ordinances, right? Just some basics about a lot of these things that are out there. It really governs like a lot of stuff relating to the landlord-tenant relationship, right? What to do if your landlord comes into your home unannounced, what to do if you're facing substandard conditions, right? Something's broke, pests, really a whole bunch of things, lockouts, security deposits, et cetera, right? But the thing about really, any good body of law is there's always going to be exceptions to it. And I'm primarily going to talk about the Cook County Residential Tenant Landlord Ordinance and the Cook County Residential Landlord Tenant Ordinance. And these exclusions are really just very high level. You can kind of get into the weeds here where, there might be other things that are excluded, like, for example, student housing, dorms, that kind of thing. But for most renters out there, right, what we see is it's going to apply to a significant amount of units, except if it's owner occupied and generally 6 or fewer units inside of a property. All right. And so in some areas, if it is excluded, then general Illinois law applies. Then is usually a little less protective, or in some instances a lot less protective, right? So things it doesn't cover, the hotels, educational institutions, religious institutions, that kind of stuff. Co-ops is an important one to be aware of, where it won't deal with it. But it does cover things, like subsidized and public housing. However, one thing to be able to note, if for folks that are in subsidized or public housing, there are certain procedures for those bits of housing, such as certain grievance procedures or otherwise, to be very, very aware of before taking some of this law into your own hands. But generally, what we're going to look at is buildings with 7 or more units. Okay, or if there's 6 or fewer units, right? If the owner or the landlord does not reside on the property. So you kind of think about those mom and pop shops that are out there. All right, Housing Law 101, conditions. So landlords just generally have a duty to maintain their property. All right, the law really spells out line by line, things that they have to take care of. Make sure floors are level and porches and whatever else. But as you sort of like look around to the 4 corners of your home, a landlord usually has a responsibility to be able to maintain that and make sure that it's livable. All right, and we have it broken down to where we can be talking about regular maintenance issues, right? So maybe like a window is broken, something sort of not working quite right, pests, that kind of stuff. Where it's like non-compliance with the lease or the law on the habitability, as we would say, for that property. So some of the remedies that are available, right? Tenants can write a letter to their landlord to say, hey, landlord, right? I'm experiencing this issue, that issue, and the other one. I'm going to give you 14 days to be able to address those issues. Okay. And if you don't fix those issues, or don't fix those issues with some level of satisfaction within those 14 days, guess what I'm going to do? I'm going to do one of these things that might be on this list that I'm showing you here. Okay. So the first thing is tenants can do some level of self-help. Okay. So what we call this is repair and deduct. Let's say doors kind of like coming off its hinges or something like that. Okay, that's probably not the most technical thing to fix. I'm going to go to Home Depot. I'm going to go buy some supplies. I'm going to, put a new hinge on that door and fix it. What this means to be able to repair and deduct is the next time your rent payment comes around, after you've given the landlord, their opportunity to fix it, and they failed to do so, that you can say, hey, landlord, I'm paying you, $1,200 a month. That little trip to Home Depot cost me $72.34. I'm going to deduct that amount. I'm going to give the remainder as rent. All right, that's what repair and deduct looks like. However, there may be some other things that might need a specialist to come in and deal with, right? You have to be able to think about your liability and what you can competently fix. And so you might have to reach out to a professional, maybe get like a couple of bids or something like that to be able to fix something and then proceed. The amount that you can do this up to is generally it's either half of a month's rent or $500, whichever is greater. All right. Now, something that comes up quite often is sometimes people experience an issue inside the property that might exceed that amount, or they might have multiple issues. Sometimes what might work here is maybe staggering them out, taking care of whichever one is, really needs to be taken care of first, and then maybe doing the repair and deduct on that one, and then the next month doing the next one, and so on and so forth. And who knows, maybe the landlord gets the idea at that point and dispatches somebody to be able to take care of it. This does get a little bit trickier sometimes if you're in a multi-unit property and there's an issue that affects several units, or at least just more than yours. There's some concerns there that I won't necessarily get into now. The next one is to withhold a portion of your rent. A lot of folks, when they see rent withholding, they will withhold the entire amount of rent, right? Landlords like to get paid. And so I'll just hold everything back until, that forces their hand to be able to take care of things. That's not the way the law is written. The law says that you can withhold a portion of your rent that now reasonably reflects the reduced value of the property. All right. I'm going to give you sort of maybe a brighter line of how that works. Somebody I helped out not too long ago, they lived in a 3-bedroom property. In one of the bedrooms, the ceiling had, the drywall and everything else had effectively, caved in, and that room was unusable. Water infiltration, it was just trash, and there was mold in there or whatever else. So what I recommended that they do is go online, Zillow and some of these other places, see what 2-bedroom properties look like in the area, and just say, well, I'm effectively in a 2-bedroom unit at this point. I'm just going to pay blank. And withholding that portion. It gets a little bit trickier when you start dealing with this issue and that issue, right? Like, okay, so this one's worth $25, a month to withhold. This one's worth $30. But if we're going to start to talk about what might be a little bit more within the comfort zone, I usually recommend that folks don't go over 30%. That's when you start to walk into some dangerous territory where a landlord, might want to evict or otherwise. And really, in no instance should anybody be withholding, more than 50%, because the logic here is there's a lot of other things that come into play inside the property that you rent, and you put it all together, and sometimes it's worth more than the sum of its parts. It might feel like, but you still, in many instances, have walls and a ceiling, and all these things kind of add up. But just a big warning for any one of these, these remedies. The withholding probably more than the other two. Landlords will give a 5-day notice for non-payment of rent. They're going to say, hey, in Evanston, 10-day. They're going to say, hey, you didn't pay me all the rent that you owe me. Here's what I'm going to do. I'm going to, demand that you pay me the full freight. If you don't, I'm going to take you to eviction court. All right. I've known landlords do this for very, very small amounts of money if push comes to shove. Then what it would come down to is it would come down to being in court and arguing to a judge that you rightfully withheld a proper amount of rent. And if you think that your landlord might, drag you into court, it's a good idea not to go out spending the money that you were withholding. It is effectively your money at the end of the day. But the idea is you might want to hold on to it just in case you find yourself in court. They can say, Judge, I got it right here. You tell me I did wrong, I'll pay up at this very moment and we'll take care of business. Finally, for serious problems, you could break your lease. What this says, landlord, you got 14 days to fix it. You fail to fix it within 14 days. My lease will be terminated and I'll move out within 30 days after that. Okay. One little thing but one thing to remember off of that is that if you don't move out at the end of the 30 days, you effectively just throw that notice in the trash. It just doesn't really have any effect at that point. All right. The other thing is not only, is there a big old list of things that a landlord has to take care of, but other things to be mindful of too is, if the landlord hasn't complied with the rental agreement, right? That's the way the law is crafted. And so if the landlord, if there's something in your lease and the landlord's not honoring your lease agreement, then you can hold them to it by doing one of these things. All right. But a crucial part of this is proving that the landlord received notice. So it's usually recommended to be able to send to them certified mail return receipt requested, right, where it has a little green card and you can prove that they signed for it when they received it. A little trick of the trade might be to not only send it by certified mail return receipt requested, but also send it by regular mail, because sometimes folks might refuse to sign a letter. And then that way, if that other piece of mail gets through and doesn't bounce back at you, you might have an argument that that they got it. But I put a little thing on the bottom. You can also never have too much notice, right? So you can also do it by mail. You can do it by email. That's how you communicate. You can do it by text, whatever, or handing it to the landlord. Anything designed to make sure the landlord, gets notice of this. On to some of the more urgent issues. Okay. So what the law says here, for one side of things, is there's something called what we call essential services, right? So heat, running water, hot water, electricity, gas, plumbing. Okay. So these big things. Unfortunately, in Chicago is working on this with cooling, because it's getting warm out there, still warm out there, where these things are essential and a landlord can't do things to disrupt it. So, you can write a communication to your landlord to be able to say, hey, landlord, take care of these things. And instead of doing that 14-day stuff, it goes much, much faster. Two other things to be mindful of too is that Cook County and Chicago also have heat ordinances. They run for a huge chunk of the year. Both of them begin on or about September 15th, right? Because it can get very chilly early on. And there's some significant penalties for failing to go with the heat ordinance, where you have to keep a minimum temperature, right? We see 68 degrees during the day, 66 at night. But with essential services, as I mentioned before, right, we have that sort of expedited schedule. Things need to be a little bit snappier. So the repairs need to be done within 24 hours in some instances, or you can begin to do things like withhold a portion of the rent, right? Or and this happened in a whole lot of properties last winter. A lot of pipes froze in certain properties and rendered big buildings uninhabitable because pipes froze, burst, and folks were put out. So a lot of landlords were paying for their tenants to get substitute housing. In some instances too, the tenants can, instead of paying the landlord rent for that period, they can spend money on substitute housing and then deduct that from their rent, or up to whatever their rental payment is. And then for certain things, right, if it's kind of the end of the line here, then tenants can make a 72-hour notice to their landlord and say, hey, I've been without heat for 72 hours or water for 72 hours. My lease is terminated. I'm out of here. Okay. And then again, it's that 30 days that you're out, and the landlord has to return security deposit, etc. The other thing is, some of those things I mentioned before with the non-compliance with regular maintenance items inside the home, there's the other issue of, well, what if those are pretty serious, right? Like, let's say you just don't need that door fixed. Let's say there's a locking mechanism on a door, and that door doesn't just face into another room in your home. That door faces into the outside world, right? Maybe not even like a hallway, a communal hallway. Maybe it just goes straight out into the street. All right. You can't wait 14 days or otherwise for a landlord to take care of that. So really that timeline that I mentioned on that essential services side, that applies to some of these health and safety issues, right? So, and sometimes these might be subjective. So if you have something going on in the home and, maybe there's mold or something else going on there, and, you have a baby, or maybe you have certain sensitivities, that might be where this would apply as well. So that's a lot to do with the essential services things. I'm going to touch on this at the end. One of the things that we have available at Rentervention is not only can we help you even 24 hours a day with an automated service where you can put some information about yourself and the issues you're experiencing and otherwise, it'll create a letter to your landlord. And not only will it create a letter to your landlord, it can also send it on your behalf. So it can send it by certified mail return receipt requested, regular mail, and or email, and or send you little images of each page of a letter to your phone via text, and then you could forward those to your landlord if that's how you regularly communicate with them. So it can be sort of a nifty tool to be able to kind of get you at that last portion of it where it might be difficult for some people to actually send it and go to the post office and go through all that. And the other great thing about it is too, it's on our dime to do that. We take care of the costs associated with it. next to be able to go on to evictions here. All right. So some of the things here, there's one little oddity, for Evanston. So for 5-day notices, right? 5-day notices that's when the landlord is saying that you owe some rent. And for Evanston, it's 10 days. But if there's an issue with the rent, what these notices will say, you got 5 days to pay me the amount owed on this notice, okay? Not a penny less. If you don't do it within those 5 days, what's going to happen is your lease is terminated, right? Your lease is ended. And if your lease is ended, then you got to go. And if you don't go, I'm taking you to eviction court. Things to be mindful of with the 5-day notice is a 5-day notice begins the day after you receive it, right? You can imagine, right? You got the notice at 11:59 p.m. You wouldn't necessarily include that first day because you really didn't have a whole day to get things together or do whatever to be able to comply with the notice. So then it goes 5 full days after that. And then you have to wait. The landlord would have to potentially wait till after that final 5th day to go into court and file an eviction paperwork against you. Okay. But if you pay up the amount that they say that you owe, then it's gone. The notice has no legal effect, and the landlord can't lawfully file an eviction against you. One thing to be able to know here too, sometimes these notices might not necessarily jibe with reality. If that's the case, within those 5 days, it's also recommended to be able to reach out to the landlord and say, hey, landlord, I know I owe you, a couple bucks. It's not that though. I owe you this, right? And to try to contest the notice. In some instances, if there's the discrepancy is so big, that could potentially be fatal for the landlord's eviction case. It's just something to be mindful of there. All of these things are very, very timely because a lot of landlords might have an itchy trigger finger in filing the eviction paperwork against people. We have 10-day notices. 10-day notices are when there's been like a lease violation other than non-payment. And with any of these two, it's a minimum of 5 days, minimum of 10 days. Sometimes a landlord could give somebody 20 days, they can give you 11 days, whatever. It just has to be a minimum of 10 days. What this says is, and this is true for Cook County, this is true for Chicago, is if you violated the lease said, like, let's say you said, yeah, you couldn't have any pets, and you went out, saw a cute puppy at the shelter, and you brought it home, the landlord gets wind of it, landlord can give you this notice. You got 10 days to cure the violation, all right? Which means you have 10 days to undo what's been done. So you got to get rid of the puppy. Then it would be a good idea to send a letter to the landlord or some sort of written communication to the landlord to say, yep, they're gone. Sorry about that, whatever else. That should be enough to be able to derail any potential eviction filing against you, okay? There are some instances, particularly like in the rest of the state, there's no right to cure it, right? So if you violate the lease, the landlord doesn't need to let you unring the bell. There's other instances where you just can't unring the bell. So sometimes if there's been criminal activity at the property, you can't cure that, right? You can't say, oh, well, landlord, I'm going to undo the, right, whatever sort of illegal activity was going on. A little bit of background about myself, other than what you heard before. Before I started helping out tenants at the Law Center for Better Housing, I used to be a landlord's attorney, and I primarily did a lot of work, in eviction proceedings. And we would have this every so often, where I've had folks where the apartment was raided by police, recovered drugs, recovered weapons, that kind of stuff. That kind of criminal activity you can't undo. One of the things we'll touch on in just a second here, there's sort of month-to-month non-renewals, right? That are a little bit of a different animal, especially in Chicago. But the one thing I won't touch on here, because it's kind of technical, is these 90-day notices. They relate to, if you're renting a building from a landlord who's going through a foreclosure proceeding, that's a whole another topic. All right. But that 30, 60, 120-day thing before, so there's something called the Chicago Fair Notice Ordinance. A little weird that they call it the Fair Notice Ordinance. It's actually part of the Chicago Residential Landlord Tenant Ordinance that I was talking about before. And what this says is, let's say you're going month to month with a landlord. All right. Or let's say maybe your first year with a landlord or first several years with a landlord, you were signing a new lease every year. And then you didn't sign a lease for the next year. Well, what do you have now? Essentially, you would have a month-to-month lease in a lot of instances. Now, there's a lot of rent hikes going on, in the area, and a lot of landlords are raising rents, a lot of times double digits. I've seen many instances of 20 to 30%. But with any of that, if you're going on a month-to-month lease, and a landlord wants to terminate your lease or like renew your lease with new terms. So for example, if they said, oh yeah, next month, rent's not going to be $12.50, it's going to be, 13 and a quarter, anything like that. There's really no limit on how much they can raise it, but there is a limit on how much notice they have to give you. So if you've been in a property for less than 6 months, they have to give you 30 days notice, essentially like a month or a calendar month. 6 months to 3 years, 60-day notice. 100 for more than 3 years, 120-day notice, right? So if the landlord doesn't want to renew your lease, I was just talking with somebody just yesterday, right? Landlord gave him a 30-day notice to say get out, and the tenant said, actually, I've been here for a couple of years now. I'm entitled to 60 days. I gave him some material to be able to show the landlord. Landlord said, okay, fine, till the end of November. So that's usually how it works. One big thing to be able to note here, when a landlord gives you a notice that might be what would be considered like the wrong notice. So they gave you a 60-day notice, but you should have gotten a 120. Sometimes tenants might think, oh, well, they gave me the wrong notice. And people have gotten this kind of advice sometimes, like, just don't say anything, right? Wait till maybe the end of those 60 days and then reach out to the landlord and say, oh yeah, by the way, that notice was garbage. You actually had to give me 120 days. The law says that they don't necessarily need to give you a new notice. They can just wait the period. So if they owed you, 120 days, they can just say, okay, fine. Instead of, rent going up 10% come December 1st, we're going to go ahead and wait until February 1st, something like that. Or if they were filing an eviction case against you or something like that, they would just have to wait a little bit longer. And that's really with is what we would call material terms of a lease too. So if they're changing any big items in a lease, or sometimes small, they have to give you that advance notice that they're doing it, because you have to be able to think this is something that you want to live with. But yeah, fair notice ordinance is really, really good. A lot of other areas don't have this. There are some instances, right, where there's like 60 days notice for renewal and stuff like that. But I'll give you some resources if you want, if you're experiencing that kind of issue. All right. So how does an eviction case work? I kind of touched on this about this, the notice, 5 days, terminating, and all that kind of stuff. So the first thing that has to happen is a notice has to expire, right? That 120-day notice needs to run its course of 120 days. Well, what happens next? The landlord is entitled to file an eviction against you, okay? They can file an eviction against you. That eviction case, sometimes they're asking for money, sometimes they're just asking for their property back, whatever else. But in Cook County, first things first, they file the paperwork, they get it stamped by the clerk of court, take that stamped document over to the sheriff's office, and the sheriff goes out and tries to serve the tenant, now a defendant, with the paperwork to say, hey, you got court on a certain date, a certain time, show up. There's other things that the sheriff is unsuccessful that the landlord can do to kind of escalate how that works. But in a lot of these instances, what eventually would happen is there's some sort of final order, right? Sometimes that might be an eviction order, right? So a judge says, all right, landlord is entitled to get their property back, tenant, you've got to go. And if you don't go on your own, then the sheriff is going to come out to the property and the sheriff is going to forcibly remove you. The other thing that can sometimes happen, and this is like sort of the art of negotiation here. Sometimes tenants and landlords can negotiate payment plans, right? So you have a balance with landlord, you pay something down over time, whatever that might look like. There could also be agreed move out dates. So a landlord might say, all right, well, here's what we'll do. If you can just be out in 60 days, I'm not going to go any further with this, right? And you sign off on it, and any one of those court orders has the full force and effect of law, right? And so there's obligations that you have, and there's repercussions if you don't live up to those. A really good thing, though, is something called the Early Resolution Program. And this was devised during the COVID period, where a lot of folks were worried about, people getting displaced, especially, you have these situations, you might be in a shelter, you might have to double up in a home and transmission of COVID. There's all sorts of ugliness that would surround that. But eviction court was never a very friendly place for people. Back when I was doing the landlord work, what would happen is you would get served by the sheriff with court papers. You'd have to be in court within about a week. You show up to court. That was your trial date. If you weren't ready to go on that first court date in many instances, then I was probably going to get my way in court. I'd go up in front of the judge. I'd probably talk anywhere between like 60 to 90 seconds to make my case to the judge. Maybe the judge would hear what the tenant would have to say. Maybe not in some instances. And there's an eviction order, right? And it's like, it would be like the fast food of the justice system. What would happen with this early resolution program is the first court date is no longer a trial date. The first court date is where the judge kind of says, okay, here's what's sort of going on, right? Tenant, would you like the opportunity to be able to speak with an attorney? And vast majority of people decide that would be a really, really good idea. They speak with a free attorney. The free attorney might talk about their rights. The free attorney might, assist them in trying to settle something and work something out with their landlord. They might step in a little bit and maybe try to talk to the landlord themselves to see if they can negotiate something. Or in many cases, they might refer to whatever organization they're part of. My organization participates in this to say, you know what, this tenant has this tenant's case has some legs, and I think the landlord was doing some bad stuff here, and we're going to take this case and we're going to fight it. And that's another opportunity for things to happen in the early resolution program. But the idea is to be able to kind of slow things down for people to come together and see if they can work things out, right? To come up with some sort of mutually beneficial arrangement. The other thing that's going on is there's a right to counsel pilot in Chicago. And for folks that might be aware of these things, the new mayor also announced that he'd like to be able to expand this program and make it a fixture in Chicago evictions. But similar to the idea of when you're facing criminal charges, that you can that you can have access to an attorney, right? That for very low income people, if they're inside of eviction court, that they would have access to an attorney who would be able to help them out. Okay, and really, this is going to be cases where there's going to be like I have this language up there, meritorious defenses, right? Again, where a case might have legs, not something where maybe the tenant has arguments why the landlord shouldn't evict them, but has like true legal arguments on why the landlord shouldn't evict them. So that's something that it's extremely important that my organization is participating in, and several other organizations are participating in. It's great work to be able to do this. It's really changing the nature of what these eviction proceedings look like. Because sometimes what people will be told is like, don't go to court. It's a trap, right? You show up to court and it's a trial date and you don't know any of the rules of the game and you walk into court, there's no hope there, right? You would never play like a board game against somebody if you didn't know the rules. It would be over before it started. And so sometimes that was the idea, is like, don't go to eviction court because it's just gonna, you're just gonna get bulldozed. But now it's in a lot of cases, it's a really good idea to go to court. There are a lot of resources available. Because not only are there resources available to be able to connect with those free attorneys, but there's also resources available for court-based rental assistance. So this is happening now. There's going to be an expanded program. It already existed, but a better program in suburban Cook County. But there's been a program in the city of Chicago for a while now to be able to see what can happen, what monies might be available to put you on better footing with your landlord. Or in some instances, right, like if where you're not just paying down a debt owed to the landlord, but potentially getting some money going towards future rent, so you can kind of get some things together and maybe breathe for a moment. But right, getting that advice from an attorney, potentially working out a settlement, that where we see these things all the time, right? We know what good settlements look like and kind of where a Goldilocks thing might be, what might be realistic, and being able to work that through. And also potentially in some instances, and this doesn't happen in a lot of cases because the law is really stacked against people, potentially sealing a court record, right? So maybe you agree to move out from a property, and work out all these great things with your landlord. Well, now you still have an eviction, like a public filing. Maybe you didn't get an eviction order against you, but somebody filed an eviction against you, and that data, that information about you is publicly available. So a landlord, a future landlord, could get their hands on that and say, whoa, 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 I'm not going to rent to this person. They have an eviction on their record. And a lot of times they don't care whether or not there was an actual eviction order signed by the judge. Just the mere filing an eviction would be enough for some landlords to turn it down. So the project that I work on, Rentervention, first things first, there's some self-help where, and I'll walk through this in a moment, where people can go on here 24/7, learn about their rights, and actually, maybe let the rubber hit the road on taking care of those rights. A big thing that we introduced on top of that, and this isn't 24/7, but it's regular business hours, but we have pretty fast responses to people, is you can call 8667 renter or text 8667 renter and get connected with our housing help desk. And this is where our staff can take questions from people and give legal information, and potentially referrals on where you might need to go to be able to address that particular issue, right? So if you're dealing with housing, but maybe there's a domestic violence issue in place, that we have some great resources to send to you. But an important number for people to be able to take note of. Again, you can call it, you can text it, and we usually reply to people in about a business day. But most of the time, it really looks like just several hours, with a lot of our replies going out in less than 30 minutes. And the other thing that we can do for some cases with Rentervention is we can help people negotiate. We can coach you, maybe like how to navigate these things on your own, and maybe negotiate with your landlord, or do some other things. Sometimes we can draft things like those letters I was talking about earlier. We can help with that. Or maybe just review a lease, right? Maybe there's a term in your lease that's confusing you, or the landlord sent you a notice or communication, where we could look that over and be able to advise people. But one of the things I want to just briefly get into, and before I take your questions, is this rentervention.com, and just walk people through some stuff, right? So I can go to this rentervention.com and I can just type something in here. I don't know, do you do any like legal wording or whatever else? But I can say something like, I have mold, right? So, okay. Now this chatbot is saying like, okay, what's this issue this person is experiencing, and kind of let me categorize it to see if I can find some good information for that. All right. So one thing that's important, right, is this is just a chatbot. It's a very helpful chatbot, but it's not a human. And it's not a lawyer. It's not a human. But one of the things it needs to know in a lot of instances is where you're located, because as I just talked about before, there's different laws for different areas, right? Oak Park, Evanston, Mount Prospect, Cook County, in a broad sense, or Chicago. And there's a lot of stuff there. So it's important to be able to put in your information. The other thing that we need to know is whether or not the Chicago residential landlord tenant ordinance applies, right? Because if you're dealing with a conditions issue like mold, that's going to be very, very important. Some other issues, it might not ask this question because it doesn't matter, for evictions or a lockout or something like that. Let's just say for our purposes that it applies to you. And if you don't know, it'll actually walk you through it, do a little quiz, and be able to help you figure out whether or not it applies to you. Some of the other things that I mentioned before, right? If you're in subsidized housing, there's some other things to be able to consider. So, but for right now, I'm just going to say I'm in straight market rate housing, and give me some resources for that. But the important thing to be able to remember with Rentervention is designed, for self-empowerment, right? Because for a lot of tenants out there, this might not be your first rodeo, probably not going to be your last rodeo, right? There's always going to be some level of conflict or something else that you're going to have with your landlord or housing provider, right? So it's very, very important to be able to understand the law a little bit better and understand the types of things that you can do under the law. That's why I just want to I put this little part in here to be able to help people along to be able to work through this and navigate these issues because it's very, very important. So what it does next is it finds some resources. And what it's done is it's gone in and said, okay, this person is dealing with conditions issues in their home because it's mold, and this person lives in Chicago, and this person lives in Chicago, and the Chicago residential landlord ordinance applies. That kind of bundles all that together, and it finds some resources that we have. These resources are articles that are written in plain language, right? We're not using any fancy legal language in these things, and they're only going to be several hundred words. So you're not going to get like a 10-page document and be like, what am I even looking at this point? And it'll summarize some parts of it to begin with, and maybe tell you which one is probably one of the better ones to go after. At any point, if you want, you can always click Get Human Help. This will take you right to our help desk. Okay, so if you don't want to go through this whole process, you're like, I don't want to talk to chatbots, I don't want to read anything, whatever else, just go straight to human help and we'll take care of it. But if you want to be able to look at things, you can check out this resource. What does a landlord need to repair under the RLTO? This will give you a little, a brief summary for folks who are just listening to me, right? This is kind of on point with some of the stuff that I was talking about. You can also do things where you can read more. This will take you to the actual article where you can read it. It might even have links inside the article to be able to create those letters and do things. So again, learning more about the issue and then taking what you've learned and applying it, into the real world. Again, offering human help. You can ask a follow-up question. So you can kind of like ask the articles and stuff, or see what some of the other articles are. But if you decide to read more, and check out the article, what's neat here is once you're in here, and you've got this little article available to you and all that kind of stuff, you can sort of begin to work through a bunch of the other stuff that we have and just start reading things on your own. So there's a lot of different articles that we have. Some are very, very short, some are a little bit longer. But it's just, I think it's a tremendous thing. We've got hundreds of these things for people to look through. Whether you're, here we have some Evanston stuff for conditions issues in Evanston, so on and so on. So I just want to show you a little bit of that on accessing that tool because I think it can be really, really helpful. We've helped folks with over 40,000 issues that have come through our doors, and gotten some pretty exciting results from it and with some happy users. But with that, I'll leave it open for some questions. And thank you again for listening to this portion.
Great. Thank you so much, Connor. I really appreciate all your expertise, and that rent-intervention tool is really great and very, very useful for people who are trying to hunt down answers. We have one of our first questions here is, can tenants legally organize a tenants organization in Evanston?
Yeah, so with a lot of these, tenant ordinances and things like that, tenants are allowed to do a lot of things. Like even the stuff that I mentioned with sending a letter to a landlord or exercising your rights under the law, where there is a prohibition against things called retaliation, right? So if you do something where the law allows you to go on the news and talk about this landlord that's super duper crummy, or contact a public official, or call 311, and get a building inspector out, or write a letter to be able to say, landlord, you got to take care of this under law. Any one of those things, they're considered protected conduct. Oh, and I'm sorry, including, organizing a tenants union, it's considered protected conduct. And so if a landlord started eviction proceedings against you or threatened to raise your rent or do other things, it has a potential that it be considered retaliatory. And so usually that kind of conduct, like the question sometimes is always like, can a landlord do this or that? They can do anything until you tell them to stop, right? And sometimes it takes, significant resources to tell them to stop in some instances. But short answer, yes. Unionization, another organization is A-okay.
If a tenant feels like they're being retaliated against for, say, organizing a tenants organization or exercising the right to repair and then deducting that Home Depot cost, for example. Who do they contact? Do they contact an organization like Law Center for Better Housing?
Yep.
Or
That's
yeah.
a great first start. There's another organization in Chicago called the Metropolitan Tenants Organization. They also do work in Evanston. They primarily do work around organizing. They do have an attorney on staff that can help with certain things in a limited way, but that's also a fantastic resource. But depending upon whether or not the tenant might be in eviction court, or not an eviction court, and what the retaliation looks like, what they do in those instances could look very different. That's a very lawyerly answer, but but there are paths forward for that.
Sure. All right. I have a question. I know that New York, for example, has recently started cracking down on Airbnbs and started regulating them more heavily. Is there anything in the works like that in Chicago or in Cook County? And how do you think that Airbnbs in general are affecting the rental market around here?
Yeah, so we talked a little bit about policy before this thing began, and policy at LCBH. I don't get involved in a lot of it, but the no real prohibitions unless it's in a lease, right? But one of the things to be mindful of too is like let's say for the Chicago Residential Landlord Tenant Ordinance and otherwise, landlords have to accept like reasonable subleases, right? Airbnb isn't necessarily like a true sublease though. So there is almost kind of like a prohibition on, like if you just started bringing anybody into that property over time versus doing like a true sublease. So I guess you could say there's like something of a prohibited thing there. But yeah, overall though, right? Like I think it's had less of an impact as people were probably once concerned about it, on what it would do to the housing supply and otherwise, and jacking things up. I might be mistaken on that, but I just don't see that as being probably one of the bigger issues when it comes to housing shortages and things like that.
What about things like landlords collecting application fees and then never leasing the apartment, just kind of continuing to take applications, collect those fees, as opposed to actually letting the property? Is that something that you've encountered?
Yeah, you see it sometimes. Sometimes I refer people to the Illinois Attorney General when they believe there's some potential fraudulent conduct going on. Sometimes too, if a landlord like doesn't, end up, like if everything looks like it's all shored up and you're ready to go, bags are packed, all that kind of stuff, there are some remedies available to when there's something called a failure to deliver possession, right? When that landlord doesn't turn over keys and kind of like gets the wheel spinning and doesn't complete it. So there's some stuff there. One thing I didn't touch on this because it could be like a whole nother topic in and of itself. There's something in Cook County called the Just Housing Amendment. So there is a process that some landlords have to go through on collecting those rental fees, and when they do it versus when they run a background check. So for example, landlords can't outright do things where they put an ad out there on Craigslist or something and say, no criminals. They have to do assessments of tenants, and they can't really collect fees until they do those certain types of assessments. So that's something to be aware of.
Okay. We have another question from one of our watchers here. They say, I was able to have the rent paid through a program. The landlord's maintenance man was not able to go to my unit to fix what was needed due to his wife not letting him in my unit. Also, I had a problem with my lights, so I called ComEd. I received a 5-day notice due to my landlord being under investigation for stealing electricity. This person has eviction court on November 15th and wants to know what they can do.
Yeah. So first things first is I'm Googling on the side here. First things first is you can go to a website called cookcountylegalaid.org, or you can call a number 855-956-5763. I can also pop that in the chat here. But the thing I mentioned before, that early resolution program, this is the hotline to be able to sort of, kick that off. So a lot of times you can begin to give some of your information to these folks rather than just doing everything on that first court date. But like really, not that you have to do this, but if it is the first court date and somebody has been served by the sheriff, or not sometimes, and they just want to go to court and get get it started, start getting those documents together. Start, gathering that information, saving those emails or doing something or printing them out. So everything is kind of, put together nicely. So when you're talking to one of these attorneys through the early resolution program, you can help paint a very clear picture of some of the things that are going on. So when I hear stuff like this, right, like potential utility tap and some of these other things going on, these can be fairly complex issues. And it might be a good idea to be able to tee that up a little bit and do that work ahead of time. Because when you do talk with one of these attorneys, it's going to make that time that you have with them so much more fruitful, rather than sometimes like I do a consultation with somebody and, the information that I give is only as good as the information that I get. And if there's a document that like would change my mind on something, I should probably see that document ahead of time, or else we're just spinning our wheels during a consultation. So yeah, check out that thing. It's Cook County Legal Aid for Debt, but that's sort of part of this early resolution program to get the ball rolling there. But again, remember that first court date, if it is the first court date, it's not going to be like do or die on that court date. And so not to be, you're going to be anxious. I get it, right? But it's not as bad as it once was.
Great. Thank you very much for that. Do we have any other questions from the participants? I'll give you just a little moment here in case you want to type anything else in the chat. I could talk all night, but no one wants to hear from me.
And I just put the rentervention.com in the chat as well. That's another thing. And then that 866 7 renter for our helpline. So
Great.
Just all important resources. We get hundreds of inquiries a month. Again, trying to do quick response times to people, giving them like good information rather than just sort of like some generalized gobbledygook.
I would just like to share that one of the very first things I was excited to do with my law degree, and I had read Chicago's renters ordinance, was tell my father that in fact he did keep the house too cold my entire childhood. It was well below the legal limit for landlords, and I was forced to live through that.
We can talk after to see.
That was worth the money right there.
We can talk after to see if there's a cause of action that you might have here. I don't know if the statute of limitation is passed on that.
Probably, yes. All right, it does not, oh wait, I see another question has come in. It says, thank you so much. So I will echo that sentiment and say thank you very much for being here tonight, Mr. Malloy. And this program, as we've said, it has been recorded, so it will go up on the Evanston Public Library's YouTube playlist within the next couple of days, and I will email that to any of our participants who are interested. Or actually, I'll send it to everybody who has registered. How about that? So everyone who is registered tonight will get a copy of that link, so you can view it again or share it with anyone else. So thank you very much, everyone, and have a wonderful evening.
Thank you. Be well.
Thank you. You too.
Bye.